Thanks all for coming along. Welcome to 2023. Seems like it might be another webinar year, so put some seatbelts on your ears because they're going for a ride. We will be talking about legislative changes today. Fairly substantial piece of legislation went through late last year. Secure Jobs and Better Pay Bill received royal assent on the 7th or so of December. So it's in operation, although not all parts of it. There's a lot of dates in here, but this is no longer thought about. It is a live piece of legislation, number of changes to the Fair Work Act. So what we'll be covering off today is really the main changes. This is a fairly overview, not getting into, because not everyone loves it, the individual line-by-line item changes to the Fair Work Act. You can thank me now or later. We'll just talk about the main pivotal changes are, and largely I've ordered this session, structured this session in what I think are going to be the main relevant changes for members, regardless of size, what are likely to have either the biggest impacts or just things that are unavoidable and are likely to impact on your business. As I say, timing is different for a lot of these different matters. Some things are already in play, some parts are yet to come to pass, and some things are a little bit unknown. I feel like I'm sounding like Galadriel now, so that's what she says to Frodo. But we don't. The Fair Work Commission has set a timetable for a number of things, including some of the changes to the enterprise agreements, and including a number of changes to enterprise agreements. They don't have the processes or criteria. Those have been left in the explanatory memorandum in the Act for the Fair Work Commission to do a bit of homework there. But we're talking about sexual harassment and discrimination. There were some changes already here. There are some more, as in there was already changes made last year, even prior to the change of government. There were some changes there. These are more changes in that space. We'll talk about enterprise agreements, flexible work requests and their disputes. Flexible work requests have been around for a long time, but there's some new parameters and there's some new processes largely attached to that. And obviously, when it comes to disputes, when we're talking about disputes in an IR world, that means, or is very likely, that there's going to be some ability for tribunal, the Fair Work Commission, to get involved. There's some new bargaining streams, some names remain the same, some names have changed, some things are similar, some things are a bit different. The abolition of the ABCC, it largely happened at the change of government because it was gutted straight away, but we'll talk about what remains there, and some changes in the equal pay space. I know talking to members a lot over the years, you know, we get, when there's changes, we get a bit selfish. There's lots of changes all the time, so we're selfish and we want to know, well, what do I care about, Jordan? What are the things that I'm mostly going to be listening out for here? So if you tune out my voice at any time, but you hear some keywords, these are some keywords that you might be looking out for. And a lot of these changes sort of happen operating in the background, and they're not front of view. Even though a lot of the changes, where we talk about substantial changes to the Act, it's still a car, it still drives, there's just a different type of engine perhaps under the hood. So there's some key areas here that I think you'll probably want to listen out for. And as I say, the most relevant changes for businesses of all sizes are going to be around the sexual harassment positive obligations. We'll talk more about that, and the flexible work requests, and the fact that the disputes will be handled by the Fair Work Commission, and that ultimately they have powers there that they just previously didn't have. Enterprise bargaining, it's a bit of a mixed bag. I put that sort of further down because that doesn't impact on all members. There's a large number of members who do get to the enterprise agreement space and enterprise bargaining. It's not fundamentally upheaved in that general single enterprise agreement space that a lot of people do get involved in, most employers do get involved in if they do get into the enterprise agreement space. I wouldn't preface it by saying it makes it more attractive or less attractive. They're just changes. The additional bargaining streams, they might feel a bit academic to many members because they've already impacted them. Interesting, not interesting, you can be the judge. And as I suggest there, that the additional bargaining streams are likely to affect our members who get into the larger bargaining space, larger bargaining spaces on larger construction sites. The equal pay changes, they affect all businesses as well. One of the primary ways, again, this is more background stuff, that the major changes will have an impact is how the Fair Work Commission is going to do things, particularly when it's considering award rates and applications around what is the appropriate award rate for a particular type of classification in a particular type of award or industry. Frankly, I'm not sure that we're going to see a whole lot in that space as it relates to electrical contractors. Those key changes are really there for industries like, aged care, disability, childcare, education. A lot of those industries that have been historically largely populated by female workers. And as I say, there's background stuff that has been going on in the past about how the Fair Work Commission has had to consider applications around remuneration. So I don't think that'll be a particularly prominent issue for a lot of our members. So sexual harassment and discrimination, this is going to be front and centre. As I say, this builds on changes that were made even prior to the federal election. There has already been established a new Fair Work Commission jurisdiction, that's sexual harassment jurisdiction, and we've already had the updated definition of serious misconduct to include sexual harassment. There might be new news to you, but not so much new news in terms of the Fair Work Act changes. What is new is introducing a positive duty for employers to manage the risk of sexual harassment, and part of those positive obligations are going to include things around training, policy implementation, and having staff with duties that manage that risk. That's not to say you're going to have, a sexual harassment a sexual harassment coordinator or contact or that sort of thing, complaints handler. It'll be that the business has to have and consider someone with duties like that to manage that area. The sexual harassment jurisdiction has had some changes as well, though, and it includes a number of things here that we've got a bit of a list of. Probably interestingly is that there's, union application on behalf of a worker, so that worker doesn't have to make the application themselves, and the multiple party applications. So one particular manager or worker, or could be a alleged perpetrator. It doesn't require a whole range, 5 different applications for then the commission to have to consider, or should we join these as a single application? The Fair Work Commission can just get those and get that one application with those parties and proceed it under one banner. That's a background change, but does streamline to an extent the readiness at which these matters can be handled and dealt with, rather than to have to go through a bit of yes or no, sir, about hearing the applications. There are stop orders similar to bullying and harassment jurisdiction. There's stop orders there about, the Fair Work Commission will have it in hearing or conciliation conference first, and they will look at what's established as being ongoing conduct, or is established as conduct that is sexual harassment, perhaps, and they can facilitate and help with either, usually first, a plan, a strategy for the parties. If that doesn't work, or there's a need for them to make a binding decision, they would then go on and make a stop order. And that can be fairly wide-ranging. We haven't seen a lot of action in this area of the Fair Work Commission, even though it's not that new. So what the stop orders have looked like and what goes into them are a thing that we're still yet to see. But that is a power that the Fair Work Commission has. A difference between the bullying jurisdiction and the sexual harassment jurisdiction is that the Fair Work Commission does have the ability to order compensation. The bullying jurisdiction was largely, particularly when it went live, if you like, when the changes were being discussed, was predicated on the fact that it wasn't a jurisdiction in which parties could go there and get some sort of go-away money, like we commonly see in unfair and general protections claims that are made against employers. So the bullying jurisdiction wasn't about that. It was about improving and identifying conduct and eradicating that. Sexual harassment jurisdiction, different. It can make orders for compensation as a remedy for past harm. Like with all things in the Commission, you could probably say safely, mediation and conciliation are the first step. So you get an application, you respond to it, usually in some preliminary fashion, and then you will meet via phone conference as the primary or preferred choice for the Fair Work Commission. And there's a thrashing out of the various issues. No binding decisions or findings about things are typically made in that. There'd likely be some agreed elements or agreed facts around conduct and the like. The mediation conciliation is where the majority of the Fair Work Commission's work is done in all types of matters, and it will be, expect no different for the sexual harassment area, so that the parties can come to a satisfactory conclusion, or at least, put a stop on further commission elements and hearings and all of that fun in order to progress the matter forward. If that isn't successful in the sexual harassment jurisdiction, it'd always be the capacity for the applicant or applicants to continue on, whether that's an unresolved conciliation matter or whether or not it just fell apart after it just didn't come to fruition, the resolution. They're like the general protections space, if you know anything about that area, the Fair Work Commission can arbitrate, but both parties need to consent to that, or the applicant in an unresolved matter can seek a certificate and proceed to the Federal Circuit Court or the Federal Circuit and Family Court within 60 days. I guess differently here as well, the Fair Work Ombudsman has increased powers to investigate and make enforcement outcomes. So there's quite a lot of involvement from different arms of the regulator, whether it's the Fair Work Commission or the Fair Work Ombudsman, who are separate entities largely. They can both be quite involved. The Fair Work Ombudsman, similar to other matters, can be involved in that process of helping with applications for parties. So what can I do? What do I as an employer, what am I likely to start to do to help, show that I'm an employer who takes this area seriously and wants to be part of the solution and not wait for perhaps a problem to arise, or show that that we're taking the positive steps. There's a range of areas which the businesses can look at, creating a safe to speak up culture. Similarly, the way we'll be looking at how we address, safety issues, making it safe for people to address safety issues, because ultimately, bullying and harassment, sexual harassment, they all represent hazards in the workplace. So our treatment of those in terms of assessing things, which we'll sort of look at later, is no different. We're looking at the risk profile sometimes as to whether or not, there is a sexual harassment or a bullying and harassment type of risk in this workplace or in this setting, or in the culture of the organisation even. So looking at some changes that the business might make there. Creating speak up channels, I would say perhaps it might seem straightforward or even obvious perhaps to say, as speak up channel is unlikely to be or is a separate to a normal what we might call a chain of command or a hierarchy within the organisation. A speak up channel in the past, they've often been referred to as, say, contact officers or HR officers, or HR contact officers, where people might take a grievance to someone outside, maybe even outside of the HR structure, outside of their immediate channel, because their problem or issues might be with a supervisor, or they might have raised the matter to a supervisor, and then they didn't feel satisfied with that they got any action, or that there was action of any kind that was satisfactory. So a speak up channel is likely to be something, is it sometimes perhaps a new term for, or a term that people might refer to as, oh, I've got an open door policy. Any issues, you come and see me. I never close my door. Those sorts of things. Well, this is a speak up channel. That's the language we're looking at here, in order to be able to encourage complaints and complainants of sexual harassment. Like with many things and changes to legislation, we always can have a look at reviewing and updating policies. In the space, we're looking at the broader spectrum of the term workers. As we might understand, worker is not simply just a worker as defined by the Fair Work Act. It's potentially subcontractors who engage with the business on a regular basis. Anyone, mentors from even apprentice organisations, or outside consultants, or businesses who we align with, construction site. Either Sparky, there'll be a plumber, there'll be a tiler, be a plasterer, so including or considering how they might contribute to our risk profile of sexual harassment and our obligation to create a safe workplace or eradicate hostile work environments. We need to consider a broader spectrum of workers. So reviewing and updating procedures around, how grievances and disputes might be resolved. You might not have an investigation process to update, but you might consider, well, what are the fundamentals of an investigation process? How do I approach an investigation? Or I fundamentally understand how an investigation might operate for, say, a safety issue, but how does a sexual harassment investigation process, does that differ remarkably? There's still cornerstones of all investigation processes, but having yourself some preparation for that is important. What we expect, members to be asking us of regularly is, well, what have you got to help us with undertaking discrimination and harassment training? And we're going to be in the space of businesses of all size, sort of looking at wanting to roll that out periodically, and having those records of staff attendance, because at that point we're looking at some areas around vicarious liability. Is the employer doing things? Am I making sure that I'm taking these changes seriously? And what do I demonstrate if I do get a claim and some umpire comes along and says, well, what are you doing? How are you showing that you are taking these matters seriously? Continuous monitoring, improvements, looking at workplace environments, and looking at risks and incidents. Does the business, or how is the business going to go about maybe a risk assessment? Do I have is there changes in my workforce profile? Do I have more female employees? Do I have younger female employees on the tools in the office? Where are the risk points, touch points in my workplace? Historically speaking, from, matters we've had for members and helping them deal with, and even, reading the good old cases that come through from the Fair Work Commission and other places, there's often a point of contact between, in organisations where there's a field contingent versus an office contingent, that those touch points where those two groups meet can be an opportunity or a risk area for sexual harassment. The payroll person can be the person who is a common touch point and might experience these things. So do we have a plan? Do we have, how are we assessing the risk for that type of role and that person? So when, as I said, there's a lot of dates here. This is one for the 6th of March this year. So it's not too far away, best part of a month away. We'll be looking at these obligations coming into play. There's, as usual, there's penalties attached to that. We always throw those in so people are aware of those things and what they are. Penalty units change, but there's substantial penalty units attached to that. Penalty units and penalties come at the end of a long process. I wouldn't be focusing on the penalty units part. At this point, I'd very much be focusing on, well, what do I need to do around my organisation to look at this area? I will move on to enterprise agreements unless there are some questions, and I have one already. There's a question around, do these penalties, obligations and penalties apply to very small organisations and businesses? In short, yes. Yep. That's why I kind of led with this one, because it was one that was going to take effect or have an effect on all businesses of all sizes. So if I lost you later on from the enterprise bargaining stuff, and then I jumped into this, you might have not caught on, but this one is absolutely going to affect businesses of all sizes. A micro business with a husband and wife team, less likely to get a claim through the Fair Work Commission, but a business with one employee, yeah, this can have an impact. This area of the Act applies. So thank you for that question. Okay, so enterprise agreements. Enterprise agreements are, I'll just briefly touch on what they are before we get into what's changing, what's going on. Enterprise agreements are a form of industrial instrument. So most commonly, electrical contractors operating as electrical contracting services providers, they're under the electrical, electronic and communications contracting award. That's fairly straightforward. Not all of our members are under that. Some of our members are under the manufacturing award. A lot of our members also engage or have workers who are clerical doing admin functions, and they're under the clerk's private sector award. So those are what are called common rule awards, and they just apply because of the type of work and the type of business that the employer is. The option after that is, well, I'd like to do a little bit for myself, and so therefore an enterprise agreement might be established. Need at least 2 employees to establish an enterprise agreement. There's a whole lot of toing and froing, and well, what do I really want one? I won't cover any of that sort of stuff right now, but certainly an enterprise agreement is not simply an employment contract that we offer someone. Sometimes people call an employment contract an employment agreement. That is not what we're talking about here. We are not talking about contracts of employment. We are talking about enterprise agreements, which are effectively like making your own enterprise award, for want of a better expression. That will apply to the business. It's based and assessed against the award, and we'll talk more about assessments later. But an enterprise agreement is a document that goes through the Fair Work Commission after being voted on by workers and needs to satisfy a number of requirements. So what we're talking about right now is elements around the procedural requirements for making an enterprise agreement, what happens when we're terminating an agreement, and how are they assessed and what changes have they made in the secure jobs, better pay changes. So starting with the procedural stuff, anyone who's been through the enterprise agreement under the Fair Work Act in the past has, like I have, been frustrated about the previous very rigid timeframes, procedural requirements, notices, documents. It was administratively burdensome and sometimes fatal to the agreement's overall approval, regardless of how overwhelmingly supportive the vote and approval by workers was. The agreement could have failed. I won't tell any war stories there, but some have scarred me where that's happened because of procedural requirements. So they've done away with things like the notice of representational rights and the 21-day requirement before a vote can occur, the 7 days before a vote, the when, where and how the agreement will be voted on, all of those sorts of bits and pieces. Those have fallen by the wayside. So that's good. The Fair Work Commission will focus heavily on the genuine agreement part, an area that the Fair Work Commission has already been focused on over a number of years, largely due to some consideration of how the words of the Act apply. But there's half the focus, if you like, was around the procedural elements, and the other half was about the genuinely agreed part. The Fair Work Commission is really going to focus on the genuinely agreed element going forward. This is one of those areas where we don't really know yet what that's going to look like, because the Fair Work Commission has its homework and its time frame of setting this, and they have set a timetable for developing new material to guide the parties, employers and employees and employee organisations, unions, on what genuinely agreed will look like. So watch that space if enterprise agreements are the sort of thing to tickle your fancy. I would strongly expect it's going to be very similar to what they are already looking for, because the Commission can still point to that being successful, that coming out of some precedent decisions, because fundamentally the terms of the Act here won't have been rewritten. They will have just looked at the criteria and seen that they have a job to do. So the forms 16, 17 and all those sorts of things, that they have been removed, and or at least they're in the process of being removed. The Fair Work Commission doesn't move hugely quickly, and that's why I also suggest, in my little bit cynical opinion, that the Fair Work Commission probably won't deviate too far from what they're already looking at in terms of criteria for assessing whether something's genuinely agreed to or not. So employers should continue to keep their good faith bargaining meeting records, or meeting records of any kind, any explanatory documents, any explanatory sessions they hold. They should continue to do so, continue to engage and keep those sorts of records. That's going to be key. And if an agreement isn't bargaining process is happening now and is likely to be voted on the cusp of these changes, well, you'd want to be already prepared for the likely things that the Commission is looking for. I'll talk about terminations, even though that's probably not the next thing logically, but I'll just stick to how I've done this slide, structured this slide. The other end of that is terminations. Previously, there was a lot of angst around terminations of agreement once they had reached their nominal expiry date. The unions largely were upset with the fact that agreement termination could be used as a tactic to effectively pull the rug out, as they are commonly described, of terms and conditions, and put everyone back to the award. So there's been a long number of years, many years, where the unions have been pushing for new criteria, or at least just a complete abolition of the ability for agreements to be unilaterally terminated, as in the employer can just apply for a termination. The criteria look like this. Would it be unfair to terminate the agreement? And that's where they'll consider things around whether or not there's perhaps bargaining going on, and is it being used as a gun to the head, as sensationally described? Is anyone covered or likely to be covered by the agreement? It's a good criteria in my view, because commonly there might be perhaps an ETU, EBA, for example, that a business has done, no longer has workers under that because a project has come to an end, is wanting to look at perhaps engage employees again because they are coming back into that type of work, or what work where they need to engage people happens. People might get a job, get on some employees, it's a union site, so they get talked into the union EBA, but then they feel like they can never engage employees again, because it's always back to the ETU EBA. So criteria to where there's not people or there are likely to be employees covered, you can provide you with an opportunity to, to terminate an agreement, reset yourself, so to speak, as a business, and then later on look at engaging people again. Is there a threat to the business, or are there likely terminations as a result of the enterprise agreement being in place? This is a good, I would say, criteria or opportunity for employers who perhaps have an enterprise agreement. There's been a significant shift in the conditions, the market conditions, and the agreement is at a point from market perspective in terms of what it can afford that is no longer sustainable. So an employer would have to build a case as to how that represents a threat or is going to result in terminations. And obviously, we're still looking at the safety net of the electrical award from an electrical perspective as our bottom line. So we're looking at some spot in between the agreement and the award as to where this should really sit now. So that could be a basis an employer makes a case to have an agreement terminated. Be prepared for evidence in that sort of a claim, because you will want to be able to demonstrate that very closely. Or the employer can guarantee to preserve termination entitlements under the agreement, and those commonly are, where the commissioners in the past even looked at enterprise agreement terminations. They're very keen on seeing how the employment is going to be maintained. So the start and the end have had a bit of a shake-up in terms of getting agreements off the ground and ending them. I guess the reason for why are we looking at those two things first, because they're already in play. Why am I not talking about the assessment of them, of agreements, because that hasn't happened yet. The unilateral termination stuff is in play already. So how is an agreement assessed by the Fair Work Commission? It's no longer a line-by-line assessment. The Better Off Overall test has had a bit of a history. Practitioners in the IR space have been a little bit confused and miffed, frankly, about the Better Off Overall test when it was first introduced into the Fair Work Act in 2009, and replacing a no disadvantage test. There were clear rules and established criteria around what a no disadvantage test was, but the Better Off Overall test description in the Act was very, very broad and therefore very muddy. What was initially thought as being a global assessment, over time, the cases that went through the Commission on where there were disputes about whether an agreement passed or not, what increasingly became clear is that the Fair Work Commission was just taking a line-by-line assessment of each entitlement condition against the award and the agreement. So as a casual working on Sunday going to get the same or better than they would have gotten under the award? Yes or no? If no, doesn't meet the Better Off Overall test. Employer, you must do an undertaking to rectify. So the change to the Act has solidified what might have arguably been the original intention, or at least gone back to perhaps that original intention of being a global assessment of it. I don't think that's, we're not satisfied, so to speak, that's going to be, oh great, that's no more problems here in this boot space. Awesome. Because there is some parameters here for, say, the union or employees to say, I think things have changed. The employer has, sold you a pup in terms of how they said this agreement's going to be applied. Because the Fair Work Commission will have to look at the reasonably foreseeable patterns of work. If you don't do Sunday work and you want to make some changes there, that's all well and good. You might be able to shave a bit off on the Sunday space. To what advantage? I couldn't just really consider. But if you start doing Sunday work, then the Commission could reconsider the agreement against the award conditions if you change the way you're doing things. Hopefully, though, there are no more undertakings. If anyone's done an enterprise agreement, it almost always came with oh, you missed this spot, or this clause was different, or this is unclear. Do this undertaking and send it back to us, and we'll then approve the agreement. The Fair Work Commission can just go, that's wrong. Any reason why you think I shouldn't change that? I'm changing that. So that would streamline the process from the Fair Work Commission's perspective, not have to wait for the administrative back and forth of receiving undertakings from employers. All right, so that's enterprise agreements. That's not bargaining. We'll talk about bargaining later. The last thing we'll say, we'll use the word agreement. However, I thought you might like a change on topic from agreements to something which will affect businesses of all sizes as well, and that is flexible work requests. Again, flexible work requests have been around since the inception of the Act, 2009. One of the common areas that was a bugbear for particularly unions and the Labor Party was that the Act never had provisions in there to deal with anything around disputes. Disputes, if the employer said no, as long as they'd responded in 21 days, there's very little the employee could do. Even though this is, and I'll just remind everyone that the Fair Work Act originally was a Labor piece of legislation. Obviously, we've had some changes to the government in the meantime. Some back and forth Liberal Labor business. This area has never been touched, obviously, by Liberal governments or coalition governments, and Labor hasn't seen it high enough on their priority list in the past. Oftentimes, governments of the day like to leave IR in the corner because it becomes a beast that can bring them unstuck. Not so much this government. They have wanted to look at a lot of these things, including these flexible work requests and what happens if there's a dispute. There is a new scenario as well. The family and domestic violence area is a new criteria, new situation where a worker or their immediate family is experiencing family domestic violence can make a request for flexible work arrangements. A flexible work arrangement, or request, just to go back to a little bit of, well, what's that again? Is where a common example is someone returning to work from a period of parental leave, maybe a mum, let's say, wanting to work differently. Maybe they're going to do I want to do the school drop off and pick up. So I want to do a 9 to 2:30 kind of thing. They might make a flexible work request in order to do that. Maybe they can work from home in this magical role that I'm making up for purposes of an example. Maybe they can work from home for a few hours before and after. And that way they can still remain, say, a full-time employee without having to go to part-time, although part-time could be a form of flexible work request too. There's a lot of different scenarios that can manifest as flexible work requests. The common ones, they come from not just any reason, not just, would you like to, because it's, I bought a new house and there's lovely birds in the background. I'd love to hear them when I'm working instead of other people. That's not a basis. You have to see the new situation with respect to workers or immediate family experiencing family domestic violence, or you need to be caring for a child under school age and a child under 18 with a disability, elderly, they're the criteria there. So the other new elements, other than the situational aspect of who can request, is disputes. So disputes about refused requests can go to the Fair Work Commission for arbitration and quite significantly binding orders on what those arrangements are going to look like. So you might say, no, I don't think this is going to work for these sorts of operational reasons. Employee says, I think you're wrong about that. I think it's totally a reasonable request. Let's go off to the Fair Work Commission. The Commission will look at a number of things as well, and these are just part of the process in any event. Have you responded to the request within 21 days of receiving the request? Have you been holding meetings to discuss, what are you looking at? What are your operational considerations? Have you articulated those? How non-negotiable are they is something that the Fair Work Commission will have a bit of a think on. Have you considered alternative arrangements? These are already things that we commonly talk to members about, is that there's obligation to consider, well, don't just say no, say, look, this is what would work for us. For example, I'll pick another admin type role for one of an easy example, because it does come up. Wanting to work from home 3 days a week, for example, but Monday and Tuesday are not good days because they're commonly the days in which deliveries come to the business, and that's part of that person's role, is to take those deliveries, ensure that they go to the right places, etc. Can't do those activities from home, and they're they're a core requirement of that role. So no, we can't have you working from home Monday, Tuesday, but let's have a look at later in the week. So consider alternative arrangements. And as I flagged already, operational reasons for refusal are very important, and I would be prepared to be quite articulate and demonstrate what those are, because we might be in the commission on them. So like with any other sort of dispute territory, unfair dismissal, terminations of any kind, we're preparing these matters in case it goes, we're going through the process and providing our responses as if we're going to get a claim, as if we're always going to get a claim. So operational reasons for refusal will be quite articulate, and we won't be airy-fairy. We won't be a bit whimsical about, I just don't think it works because of timing or something, something as iffy as that example. And flexible work arrangements, again, this is something that will affect businesses of all sizes. So I think that will be very interesting going forward as to how the Fair Work Commission is going to, because they're being told to, not asked to, they're being told to, well, Fair Work Commission, you've got to look at the Fair Work Act and this business and now say what is an operational concern or consideration. And you're really getting into an area, I think, that the Fair Work Commission hasn't really been doing a whole lot of historically in all the versions of the tribunal beforehand, where you're really getting into the mix of what is usually been left alone by the Fair Work Commission around managerial prerogative. How do I determine how the business is to work and how work is to be arranged? So that's interesting from looking at these matters from an outside perspective. When you're going through the thick of it, I'm not sure you're going to find the academic nature of those sorts of considerations particularly interesting. You're just going to be a bit grumpy that you're going through it at all, I understand, but obviously give us a call and we can help you articulate those operational requirements and what you might mean, and obviously be a new area that we might be assisting members in the Fair Work Commission in a representative type aspect. We might get busy out of it. We'll see. So I haven't had any questions for a little while on any of those areas. So good news, bad news, tuned out, put you all to sleep, I'm not sure. So I'll move on to the next area around bargaining frameworks. This might be purely academic to most of you here, frankly, and it may have no relevance to you whatsoever. But it is important to understand some of these things, because I think particularly businesses of a slightly larger size, and I'll be looking at those businesses close to or around 20 employees, this may become relevant to you whether you like it or not. Whether you've been involved in bargaining before, anything like that, you might find yourself getting these new terms of cooperative workplaces and multi-enterprise agreements and those sorts of things thrown at you, and you didn't think you'd ever would. Multi-employer bargaining has been around in the Fair Work Act since 2009. It really hasn't been used in the past, and I think one of the probably key reasons for that, it hasn't been very attractive to unions, for example, because they haven't been able to take in the past strike action or industrial action, protected industrial action in support of multi-employer bargaining things. And in fact, the shoe was kind of a little bit on the other foot from the employer could have gained some advantages from multi-employer bargaining arrangements more so than the unions, chiefly around the fact that there was prohibition on taking industrial action where it's multi-employer bargaining. Not so anymore. Yes, there's a carve out for the construction industry, but that's just the definition under the Building and Construction on Site Award. That doesn't include trades, us, electrical contractors. So the ETU, if they would like to have some fun in this space, plumbers union, etc., they can. This is an area in which they would likely be able to do that. We're considering whether or not how much this is going to have an impact on the current Queensland round of bargaining, because there is the Tier 1 EBA is due this year, is nominal expiry date. So there's a round of bargaining that is coming from a ETU EBA perspective, and there's a whole lot of wondering largely as to whether or not we're expecting to see multi-enterprise bargaining in this space. What we're likely to expect here. I think Jason's popped on. He might have something to add on this space as well.
Yeah, and just the other thing, the ETU is probably not the only group that are going to use this as well. I've certainly seen examples in the media already where large Tier 1 competitors in different industries, for example, the air conditioning manufacturers area, they have already decided amongst themselves that the Tier 1s actually do want to get together and have this sort of common agreement, because it then means that they don't have to compete with each other on wages. So it takes out that. However, what it also does for them is that it may also be able to rope in those smaller manufacturers in their industry that are competing on price and are competing with lower overheads because they're not at the attention of the manufacturing union, and it actually ropes them up to pay the same sort of wages, etc. So it's also that situation that there's not only unions that may actually see this, but there are also larger companies that might see this as a way of shoring up their market share in certain industries. So it's and it's something that I'm particularly concerned about in that large Tier 1 construction area as well. So even though the CFMEU has been banned from doing these sorts of issues or this sort of bargaining, I think some of the other sub-trades, the plumbers, the ETU might look at it, but some of the other larger organisations might look at it as well. So yeah, it's an interesting space, and we'll have to wait, probably 18 months, 2 years to see what the actual effects of it are. Thanks, Paul.
Yeah, no, thanks, Jason. That's a good point. And also makes me think of some previous rounds with our members in that Tier 1 space in the ETU EBA, where it's been a fairly common bugbear. Yeah, okay, we'll sign this EBA, but for years, you've promised to go and get ABC Electrical, who also do similar work and have been doing exactly what Jason has described there, of coming in with lower overheads and lower wage costs, labour costs. So now there's the ability to say, well, okay, you show us that they're on that that they've been joined as a multi-employer thing. You can again, interesting space. Maybe there's a prospect of getting those people in the shed, whether they like it or not too, and finally dealing with some of those perhaps historical issues about that. So interesting. I'm not sure that it particularly favours one or the other, even though unions do have some more rights here. It will be interesting to see what happens out of that space. There's some interesting things. Look, I won't get bogged down into all the different areas of it, because this bargaining stuff is, we don't know how it might be used, because bargaining is often a strategic thing in terms of using the Act. I think it's interesting that we will see employers having to get the consent of unions to bargain or vote, or they'll have to go to the Commission to lodge a dispute in order to be considered. So that's interesting. As I've mentioned, the carve-out for construction industry doesn't include trades. And the Fair Work Commission has some enhanced bargaining dispute powers around these sorts of things, intractable bargaining declarations, and they're looking to try and make it easier to access arbitration in disputes and issues that they haven't been able to do in the past. Question here around that number, the magical number of 20. If you keep your employee headcount under 20, you'll be mostly able to avoid this new bargaining framework. Yep, you would. There's, that that threshold is a hard threshold. So this one is only those businesses who are at 20 or more are likely to be can be caught up in this space. So that is helpful from that perspective. Having said that, though, it really depends on a whole range of factors as to whether or not bargaining will be an issue for you. Then in terms of these multi-employer bargaining agreements, then you'll be out of that space. The follow-up question to that is, well, what if it's a 50-story building? Is that going to be large construction? That would be the typical space, perhaps, for the usual single interest, or because that's still the thing, single interest enterprise agreement where the union wants to bargain just in the normal fashion that it has. So it doesn't exclude you from bargaining entirely. It's just about this multi-employer stuff. And are they going to bring along the same agreement or a very similar looking agreement to their multi-employer agreement to you as a smaller business, and then put pressure on you to sign that because that's the standard in the industry? Yeah, you could expect as much, and that's really just what they do already. So it's not going to exclude you from bargaining framework entirely. I wouldn't look at it as that kind of an opportunity. It's just about, that 20 employee element is who's going to get caught in this multi-employer stuff versus, I guess, the smaller number under 20 who are in that just traditional enterprise bargaining space. And my answer to that question was, I would expect you're going to be in the traditional bargaining space with that, and it would probably look like whatever their multi-enterprise employer agreement got to. What are the parameters? Question around being forced into an MBA. The common interest, do you do the same types of work as, let's say, a larger Freedon, Paragon, Stowe, those large, looking for tier one, on tier one sorts of jobs? Am I likely to be forced into an MBA that's from them? Or you would argue, I'm not a common interest employer. I don't do that type of work. I'm a purely service and maintenance-based type business, perhaps, and I'm not on those large constructions, so I shouldn't be in this space. I shouldn't be trying to be joined into that multi-employer bargaining. Jason, you wanted to add a bit there?
Yeah, and one of the things I get worried about this too is that it's, and Jordan probably remembers this back in the day, back in the 92, 94 sort of period, we actually had what we called response awards. So what I'm concerned about, which is that the ETU may, somewhere in one of the states around the country, may try and replicate the electrical contracting award scope and make those who are 20 plus part of an MBA and go after it that way. It's doubtful they get a lot of buy-in for that on the basis that it's takes a lot of effort to get there, and they haven't been able to do it in the past. The enterprise bargaining agreement really only goes to tier one, and in some cases tier two. It certainly doesn't go down to tier threes and fours. But there is a possibility that they could do an industry-wide type coverage agreement to try and capture it. And the reason I say that is, if you look at the enterprise bargaining agreement, that is the standard agreement in Victoria, where they have had a lot of success in dragging people into it, it does cover, a broad cross-section of the contracting, including what they call down there the cottage industry. So it's something that I think in other states we will see probably a bit more progress towards, rather than just Victoria, maybe not, because Victoria's probably pretty set with their patent agreement. But other states, I think there'll be more scope for this to be used on a whole of contracting industry sort of coverage issue.
Yeah,
we'll have to wait and see.
Yeah, again, probably another one of those areas where it's very much a wait and see. What are the opportunities here, and none of this stuff, comes overnight. So, and how can it be utilised? The intention of some of these changes, whether I'm not saying I agree with them necessarily, or what it is and I'm even paraphrasing what they are, it's to sort of shake up the way and change the way bargaining is conducted. There's been a lot of commentary in the past about bargaining being dead. As IR practitioners, we see all these things around, oh, come and see this lunch, and so from South Australia is going to talk about how bargaining's dead. And that's been a pretty prominent topic for a long time. So, bargaining and enterprise bargaining has been a way in which the industrial landscape has been a feature of the industrial landscape for a very long time. And if it needs a shake-up from the government's perspective, then okay, this is their attempt at that. What are the consequences, intended or unintended, or any at all? That's just yet to be seen. All right, we're in the sort of home stretch now. I promise some of these slides won't be perhaps quite as long, or talking about them for not as much to say. As I mentioned, ABCC is removed. The Australian Building Construction Commission is what that stands for. What is that? You might have forgotten or never heard of. That's where there was federally funded projects. The Australian Building and Construction Commission had some jurisdiction there by virtue of establishing some code and guidelines. There's been a number of versions of that over the years, from 2000 all the way back to 2006. Unfortunately for Jason and I, we've seen them all. Are we sad to see the ABCC go? Yes, we are. It was a cop on the beat, and in our view, because we've seen all of the guidelines and its success under various formats, it certainly brought about some change in the construction industry, from a behaviour on-site conduct perspective, from particularly the CFMEU and the way they, ran roughshod over large sites. We are disappointed to see the ABCC go, and we've said so much, but it's not there anymore, I guess. And it was largely gutted at the beginning of Labor's tenure. They will establish going forward, July 23 this year, a National Construction Industry Forum, so less of a cop and more of a consultant, perhaps. That code had different names, but we always just ended up calling it the code. The 2016 one has been repealed. It's not applicable in any way now. So no more assessments, no more filling out declarations. Agreements can have whatever's allowable under the Fair Work Act can be in there. There's no separate assessment of what can go into an agreement now. No more higher penalties for building participants. They got quite high, but now it's just whatever's applicable for breaches of the Fair Work Act is what's around. As I say, the co-compliantness of an enterprise agreement is no longer an issue. Issues around right of entry breaches can't go to the ABCC, or breaches of the code and sanctions. They're no longer things employers are likely to be covered by. And if there is things like unlawful industrial action on a site, or there's an allegation of it, then the employer has to make its own Section 418 application to the Fair Work Commission to seek that or for an order for that action to stop, which is a traditional thing that employers have had to do in the past, but that is your main avenue. And that includes things around alleged breaches to freedom of association and coercion. They all have to be dealt with in their normal way under the Fair Work Act and the Fair Work Commission. Another area of the code and the ABCC was to really, try and stamp out elements around union organisers coming on site for a safety walk with a FBOS machine in hand and finding the people who hadn't paid their dues and making them get their wallet. So that not representative of freedom of association in our view. Equal pay, as I say, this is perhaps largely in a back of shop for the Fair Work Commission matter, so it won't get a lot of play for us operationally. Good news, got enough work up ahead in the earlier slides and worries out of the earlier slides. It really comes down to what is called a work value case, and how is the Commission going to assess wages. They're establishing a new expert panel to determine things like wage floors for different classifications in different industries. Probably one area that will impact employers, depending on how they've written their employment contracts in the past, is you're no longer able to have any clauses about the confidentiality of someone's remuneration. So people have the workplace right specifically to say, oh, I'm on $42 an hour. What are you on, Johnny? It is entirely Johnny or Janet's choice as to whether or not they want to answer that question. And as it is a workplace right, and I've chucked it in some quotation marks there, you guessed it, if you breach it, or maybe you didn't guess it, but if you breach it, you can get a general protections claim. You know, if you warn someone for revealing their rate of pay or asking about it on site, or you dismiss someone for, you know, telling people they should be getting more money, for example, which is something that traditionally employers have been a bit miffed about, people stirring up trouble on site around rates. That is exercise workplace right. Obviously, the way they conduct themselves might be an issue, but it is a right to say, I'm on this rate of pay. Any existing contract clause with a you can't tell people what your rate of pay is kind of clause is just simply unenforceable as of the 7th of December. So that's probably the area of the equal pay area of the changes to the Act. That does affect everyone. Having said that, from as long as I've been involved in with trades of any kind, it's always understood that tradies, the first thing they do on site is to say, "G'day, my name's Bob, and this is how much I'm on." And apprentices love to do it at TAFE too, and stir each other up about who's getting what allowances and whatnot. And then I get questions, and Emma gets questions, get to questions. So it can be fun, but it's now a workplace right to do that. Already we had workplace rights about protecting people or about making inquiries or complaints around wages. This is just another step to that. That's probably the most fundamental changes to say to the equal pay stuff. I don't really have anything more to say about equal pay because, as I say, the remainder of it happens at Fair Work Commission level in their consideration of applications. So final thoughts, as I've indicated, you know, businesses of all size, the sexual harassment and flexible work arrangements will be areas you need to consider and look at. Maybe you don't need to do something immediately about flexible work requests, but when you get one, you're going to need to go, well, that's right, I heard that thing about flexible work requests. I probably need to phone a friend. We can be your friends. Enterprise agreement changes. That's going to be a mixed bag from the perspective of whether or not employers are even in that space. And with respect to the procedural stuff, I think that is helpful. We haven't really done a whole lot of termination applications for members in the past, although maybe members are looking at that now going, I think those rules are a bit better for my scenario, so maybe I'll look at that. But if you haven't had anything to do with enterprise agreements in the past, that's maybe interesting. And nothing more. Multi-employer agreements and multiple bargaining. Yeah, that's a space we might see some shifts and changes. Will it result in respondent awards like Jason indicated? Will it result in, better outcomes for groups of employers as well? Maybe. Will it result in industry-wide strike action? Maybe. The 20 employee plus mark is an element, but only around the multiple enterprise bargaining. Traditional enterprise bargaining will still be there as it largely is. So that's been a shotgun of the final of the changes. Number of different dates there: 7th of December, March, August, June. So yeah, watch out for those. We will have more material coming along, starting with that sexual harassment stuff in the coming period. Jason?
Yeah, I think, in terms of the sexual harassment positive obligation stuff, we are certainly looking to put some online resources available to members to use over the next few weeks to make sure that there is at least a starting point for companies to have a look at. Obviously, we've got policies available as well for people to help with that. Again, they're all included in the membership things like that as well. So we are still, there's a couple of other things that I'm toying around with at the moment that I haven't floated past the organisation yet to assist members in this area, particularly for the sexual harassment possible obligation stuff. I just need to do some work on that over the next couple of weeks, and we'll come back to members with that. But certainly, as a bare minimum, we'll have some online learning resources and standard policies and procedures and stuff for people to use, and go from there. Enterprise agreements really talk to us because everything's different and in terms of your own individual business and circumstances, and go from there. So, but yeah, that's probably it from me. Jordon.
Thanks, Jason. In terms of, there's a question here around resources for managing domestic violence, flexible work requests. Fundamentally, the flexible work requests and its approach is the same. It's just a new criteria of which someone can make a request. The request might be, at its practical application, a little bit different in order to manage their domestic violence circumstances. But in terms of flexible work request, the material is, just give us a call. Because what is the request? If operationally it's something you can deal with, then you probably don't need to call me. You just go, well, okay, yeah, that's the request. We agree. If it's something you think you can't manage operationally, then that's where I would expect we're having a chat about the operational reasons for that, how you're going to articulate that. Make sure you give us plenty of time to help you with that, because you'll likely have a bit of legwork and evidence gathering in order to determine, well, how are you going to articulate those operational issues. I would suggest what you're going to do first with a flexible work request is consider its operational impact. Well, perhaps, is this person eligible to make a request? If yes, what's the operational impact? Can I agree to it or not? Where you need some assistance, by all means, give us a call. There's a further question on the webinar. Yes, there's a recording of the webinar that will be done and it'll go out after this session, not immediately after, but later in the week, including the question and answers and our responses. So yes, we will be making available to those who've attended the recording, which will include the slides and the questions and answers. Question around disclosure of hourly rates. Is conduct whereby workers take this further and incite dissatisfaction among broader workforce approach the employer collectively, threaten to leave unless wages are reviewed? Can this be seen as misconduct? Conduct about how people go about things may be a feature, yes. Workers coming to you collectively and saying, well, we think wages should be increased for myself or others. No, that's not misconduct. There's no doubt 1,000 ways we could play with that type of scenario where it both is and isn't misconduct, because conduct comes down to the conduct. So it would depend on how things are going, but how things are raised, how people approach it, the proportions of response by the employee to your answers to why these things are different, perhaps. But to where someone's upset because they're not on a higher rate than somebody else, and they tell you that, that's not misconduct. If they get into the swearing and inappropriate conduct as part of that, then you'd be saying something like, you have a right to discuss these terms, but you don't have a right to be inappropriate in the workplace. So that's where we're looking at the line in that sort of a matter. Thank you. All right. Well, that's the Secure Jobs Better Pay bill in a shotgun of information. Hopefully it wasn't too much in some areas and just enough in others. A lot of this stuff will be, well, let's watch this space. So by all means, as these things crop up for you, by all means, give us a call, and the employer advice team, myself and Emma and Jason, he can take your call if you got a particularly curly one that you think you might like. But yeah, thanks a lot for everyone coming along. Hope you have a good 2023, and I'm sure we'll talk further on some of these topics as we go forward. Thanks very much. Speak to you later.